Good evening, students. It's Tuesday night. I want to try to get through all these cases tonight, um, that's going to be our goal tonight is to get through all these cases. One thing that's important, I noticed that not all of you have watched the video, um, the chapter 20 introduction that I posted the other night. So it's important that you go ahead and watch that to help understand what's going on here. So here in case one, what we have is we have a company that purchased watermelon seeds. And the watermelon seeds, when they purchased them, they stated that the seeds were high quality seeds. Now I think you all understand that high quality seeds is sales puffery, that's not a warranty. But that high vitality, meaning energy, vigor, meaning physical strength and germination, that is that they would germinate, was what the warranty was. Well, as it came along, they planted them, they grew rapidly, but by mid-July, they had purple blotches that spread over most of the crop, and by the end of June or July, the crop was ruined. It was later determined that the crop had been destroyed by watermelon fruit blotch. Hall Farms lost profits from the crop of $180,000. And they sued for breach of express warranty. Well, if you look at what the warranty was, high vitality, that is energy. Notice the facts say that they grew fast. Physical strength, they were large plants, and they did germinate. And so when Hall Farms sued for breach of express warranty, the court said, wait a minute, these seeds were exactly as warranted. They grew strong, they grew big, they grew rapidly, and they germinated. Exactly what the express warranty said they would do. All right, case two. Case two is an interesting case. It's an airbag case. And in case two, the owner's manual, which would be construed as part of the contract, the owner's manual said that the airbag would deploy if the car was struck hard enough. Well, the car was in fact struck. The people were injured, but the airbag failed to deploy. So the question in this case is, is hard enough an express warranty? Now, I think we would all agree that if the statement would have been, if you're going 20 miles an hour when it struck, the airbag will deploy, I think we would all agree that that would be an express warranty. But what's the definition of hard enough? And that's then what creates a problem for our plaintiffs. The owner's manual said that it would deploy if struck hard enough. No definition of hard enough. They were unable to enunciate a standard that told them what hard enough was, and therefore they were unable to recover for the express warranty. I want you to contemplate whether they might be able to recover for the implied warranty of merchantability. That is fair, average quality, pass without objection in the marketplace. Owner's manual said that that it would deploy, and I think you have to contemplate then whether the implied warranty of merchantability might come along and save our plaintiffs. Okay, moving on to case 3. What we have in case 3 is a 1972 Ford Mustang in which one of the taillight assemblies was installed the wrong way, and that caused the taillight assembly to rust. But it began rusting after over 2 years and after 75,000 miles. And so the question becomes, was this a breach of the implied warranty of merchantability? And what the court said here was, no, it wasn't. It went 75,000 miles. It was fair, average quality, passed without objection in the marketplace, meet the reasonable expectations of the consumer, and 75,000 miles before the rust set in seemed to do all of that. Okay, case 4. Case 4 is one in which we have somebody that gets something in their food that doesn't appeal to them. They think it's a worm. Some experts claim that it was a large blood vessel, an aorta, or a trachea. The question is does this violate the implied warranty of merchantability? Well, there's actually 2 tests, and these 2 tests are on page 509. The first test is this foreign versus natural. So in this case, if this object was a worm, that would be a foreign substance and they could recover. If it was, in fact, just an aorta that got left in there when the chicken was prepared, then that would be something natural and therefore not a violation of the implied warranty of merchantability. Think of popcorn when you go to the theater, right? Not only do you get the popcorn, but in the bottom of your popcorn thing, you have all those unpopped kernels. Okay? So those unpopped kernels would be natural, but think what would happen if you ended up with a finger or a ring or something like that. That would be a foreign substance, and then I could recover based on it being a foreign substance. So that's the first test. The second test is, and based on that test, assuming that it is an aorta, I think it's pretty clear then that they cannot recover because that's a natural thing that's in the chicken, and therefore they can't recover. If in fact it's a worm, yes, of course they can because it's foreign. Under the other test, again, this is on page 509, is this reasonable expectations of the consumer? Does this product meet the reasonable expectations of the consumer? If this was either an aorta or a worm, obviously this would not meet the reasonable expectations of the consumer, and therefore our plaintiffs could recover. Okay, case 5. In case 5 is actually a fairly easy case. If you look on page 509, it defines the 6 things that you have to have in order to comply with the implied warranty of merchantability. And one of those things, I think it's item number 4, says that it has to be properly packaged and labeled. And here this product was not properly labeled. There were no labels on it. In addition to that, we have a fitness for particular purpose problem because this product was supplied by the Don Walter Christian Distributors, Inc., as part of a package deal. They just didn't walk into a store and get it. But this Don Walters Inc. Provided them with the product as the appropriate product. And so you have both an implied warranty merchantability problem and a fitness for particular purpose problem. All right, case 6. Case 6, I have to tell you, is one of my favorite cases in the entire textbook. Because what happens here is this lady, in an attempt to commit suicide, climbs into the trunk of a 1973 LTD. And this 1973 date is an important date. And she stays there for 9 days. On the 9th day, they discover her in there, pull her out. She lives, and then she sues Ford for negligent design because they did not provide an internal trunk release on the inside of the trunk of that car. And so the question is was this a negligent design then based on Ford? The Ford had. Okay, so Ford had an obligation. This is on page 515. Has a duty to avoid reasonably foreseeable risks of harm. And so the question was, in 1973, for Ford, would it be reasonably foreseeable that some person would climb into a trunk of a car, be put in the trunk of a car, and be left there unable to get out? And in this case, the court said, no, this was not reasonably foreseeable because this had never happened before. However, after this case, it then became reasonably foreseeable that this could happen. And therefore, what you have now is you have an internal release on the inside of all modern cars. And if you wanted to test that, you could go climb into the trunk of your own car with a family member, and you will find a trunk release there that allows you to open the trunk. Because now, at this point, it is reasonably foreseeable that this could happen to someone. All right, I'm going to skip case 7. I'm going to go to case 8. You know, if you've ever held and looked at one of those little Bic lighters, you'll notice that now those Bic lighters have a little tab on the side that when you lift up on the tab, the flame goes out. Well, at the time this case was happened, there wasn't that tab on the side, so I could strike that Bic lighter and the flame would stay on until I did something to put it out. Much like a Zippo lighter. A Zippo lighter, once you strike it, it will continue to burn until I close the top of the Zippo lighter. Well, that's basically what we had here, was a lighter that just kept going until it was intentionally shut off. Well, this child then comes along and lights the lighter and proceeds then to burn down the house or the apartment where this child and her mother lived. Well, so the first question we need to decide, is this a negligent design problem? To avoid risks that are reasonably foreseeable. And The court in this case said that yes, it was reasonably foreseeable that a child could get a hold of this lighter because they're in purses, they're on tables, they're all around, that a child could strike it and turn it on, and that it could continue to burn and cause a catastrophic accident. In order to recover for strict liability, I have to show that this product is in a defective condition, and because of that defective condition, it is unreasonably dangerous. Now, I'm sure that you can think of products that are dangerous. A car can be dangerous. A knife can be dangerous. A gun can be dangerous. But it has to be unreasonably dangerous in its defective condition. Okay? You'll notice if you've ever held a pocket knife, most of those pocket knives now have locked blades. And it's pretty easy to think why. Is that if I do not have a locked blade, that blade can come down and cut my fingers. Okay, especially if it's a large knife. Small knives, you a lot of times don't see those locking blades, but on large knives you do, because that would be a defectively designed, defective condition that makes it unreasonably dangerous. The same with a gun that just discharges randomly. It would be in a defective condition that makes it unreasonably dangerous. So that is the key to strict liability. Is it in a defective condition, and is it unreasonably dangerous in that defective condition? And again, the court ruled that it was unreasonably dangerous in this defective condition, and they were able to recover. All right. Case 9, you can see on case 9, page 517. I'm just going to read to you here for a minute. I'm on page 517. Because it is the most common version of strict liability in the product's context, we limit our discussion of the subject to section 402A. It provides that a seller engaged in the business of selling a product is liable for physical harm or property damage suffered by the ultimate user or consumer of the product if the product was in a defective condition, unreasonably dangerous to the user or consumer of his property. Well, here this one presents us with quite a pickle, because they had this, and it was defective in that there was no oxygen that could reach the feed. It's supposed to limit the oxygen reaching the feed. That, however, failed. The question then becomes, does that make it unreasonably dangerous? Does that make it unreasonably dangerous, and therefore they can recover under 402A? Anyway, spend some time with on page 517 and think about case 9. Case 10 is, if you've ever had NyQuil and there's those clear cups that have the lines on how much cough syrup you're getting, that's what we had here. And again, this is a negligent design problem. And Gal, I don't know. I don't think that this was a negligent design. I think you just had nurses that were overworked, misread the cup. Even though they had used this cup on a regular basis, they just misread the cup. Problem was with the nurses and not with the cup manufacturer. Okay, case 11. Case 11 is I got some bad seed. They have this language in here that says basically that I'm that if something goes wrong, the only thing I'm entitled to is new seed. I'm not entitled to anything else. And so the question is what would be their best arguments to recover? One would be, the concept we talked about earlier in the year, that it's an adhesion contract. Another one would be that it's an unconscionable contract. And under either of those two theories, they could argue that while all the industry does this is an unfair provision, and then therefore, court, you need to ignore this provision. In case 12, you have a contract that specifies what type of remedy is available. And the problem here in case 12 was that this remedy didn't help our plaintiffs very much. And so they wanted a different remedy that was not provided for in the contract. And the remedy they wanted was to not pay the original supplier for the steel, but to go out and find another supplier of the steel and get new bridge girders from this new supplier. When they didn't pay the original supplier, the supplier sued them, said, look, the remedies have already been specified in the contract. This was not one of the remedies. And in fact, the supplier actually won. So McKinnon got the privilege of paying for their materials twice. They got to pay for them, the bad ones, and they got to pay for the good ones. They got to pay for both sets of materials. Okay, I think that's enough cases for tonight. We'll do 13, 14, and 15. I'll post those up there on Thursday night. I'll also lecture on chapter 21, and then we'll move on. We'll move on from there. All right. Have a good night. Please email me if you have any questions about anything we've done tonight, and spend a little bit of time with case 9. And with that, good luck and good night. Bye.